Hello everyone, it's Ahu Meryem Erdoğan from Public Procurement Authority. I would like to salute you with respect on my behalf and on the behalf of my authority. In this presentation, we will focus on how the review and remedy system works in Turkey, who the main stakeholders are, and how the complaint and appeal applications about public procurements are resolved by the relevant actors in the system. Within the presentation plan, we will discuss public procurement system in Turkey, basic laws for public procurement, public procurement authority, procurement procedure, the main structure and the basic rules of the review and remedy system, reviewing of complaint applications by the contracting authorities, reviewing of appeal applications by the public procurement authority, and finally, judicial review. There are two basic laws for the public procurement system in Turkey. These are the Public Procurement Law and the Public Procurement Contracts Law. The Public Procurement Law aims to establish an integrated procurement system that ensures efficiency, confidentiality, and transparency in the implementation of public procurement procedures. So the general purpose of this law is to establish the principles and procedures to be applied in any procurement made by public authorities and institutions, governed by public law or under public control or using public funds. The Public Procurement Contracts Law includes the principles and regulations that should be included in the contracts signed as a result of the procurements. In this respect, the purpose of this law is to determine the principles and procedures for the regulation and implementation of the contracts for procurements made in accordance with the provisions of the Public Procurement Law. Within the framework of these laws, public procurements in Turkey mean proceedings which involve the award of a good, service, or work contract to the tenderer, which is selected in accordance with the procedures and conditions laid down in the Public Procurement Law, and which are completed by signing of the contract following the approval of the contracting officer. In 2019, the total GNP of Turkey was nearly $761.4 billion. When we look at Turkey's main figures regarding public procurement within this year, public procurements had a very important size in the total GNP with $25.17 billion. Approximately $21.52 billion of this amount was realized within the scope of the procurement procedures under the Public Procurement Law, including direct procurements. In 2019, the number of procurements concluded was 95,109. These procurements were held by 9,524 contracting authorities. And the number of contracts signed was 114,366. In this context, with their significant size, public procurements play a critical role in the preparation, execution, and direction of Turkey's economic policies. Public Procurement Authority. The authority was established by the Public Procurement Law in 2002. With public legal entity, the authority is a regulatory and supervisory body in the public procurement area. It's administratively and financially autonomous. It's assigned and authorized for the accurate implementation of the principles, procedures, and acts specified in the Public Procurement Law. It is independent in fulfillment of its duties. No organ, office, entity, or person can give orders or instructions for the purpose of influencing the decisions of the authority. The authority comprises of the Public Procurement Board, Presidency, and the services units. The decision-making organ of the authority is the Public Procurement Board, consisting of 9 members, including a chairperson and a vice chairperson appointed by the President. The fundamental and permanent duties required for the services of the authority are executed by the professional staff, consisting of the public procurement experts and assistant experts, together with the other staff. What are the main duties of the Public Procurement Authority? To prepare, develop, and guide the implementation of all the legislation concerning the public procurement law, public procurement contracts law, and standard procurement documents. To evaluate and conclude any complaints claiming that the acts of contracting authorities are in violation of the public procurement law and the related legislative provisions. To provide training on procurement legislation. To provide national and international coordination. To gather information, compile and publish statistics. To keep records of those who are prohibited from participating in procurements. To carry out research and development activities. To regulate the principles and procedures with regard to tender notices. To publish public procurement bulletin in printed or electronic media. The public procurement procedures implemented under the public procurement process in the context of the public procurement law are open procedure, restricted procedure, and negotiated procedure. Open procedure means a procedure where any tenderer can submit a tender. Restricted procedure is a procedure in which tenderers who are invited following pre-qualification by the contracting authority can submit their tenders. Restricted procedure may be used in procurements of goods, services, and works, where open procedure is not applicable due to the fact that the subject matter of the contract necessitates expertise or high technology, and in procurement of works with estimated cost exceeding the half of threshold value. Negotiated procedure means a procedure which can be used in cases specified in the public procurement law, which is conducted in 2 stages, where the contracting authorities negotiate with the tenderers about the technical details, implementation methods, and in certain cases, the price. Direct procurement. In addition to these procedures, the legislator has determined another tender method. Direct procurement means a method which can be used in cases specified in the public procurement law, where the needs are directly procured by negotiating with the tenderers, invited by the contracting authorities about technical terms and price. In order for the procurements made within the scope of the public procurement law to be the subject of complaint or appeal applications, these procurements must be carried out by the open, restricted, or negotiated procedure. Therefore, public procurements made by direct procurements are not subject to complaint or appeal applications. A significant portion of the expenditure spent for the public procurements in Turkey are carried out according to the provisions of the public procurement law. So, the public procurement review and remedy system has to be established and developed on the basis of the requirements of the public procurement law and other regulatory legislation, such as the regulation on applications regarding procurement and the communique on applications regarding procurement. Review and remedy system in Turkey is consisting of 3 stages. These are complaint process to the contracting authority, complaint against the decision of the contracting authority to the public procurement authority, and judicial review. The complaint and appeal applications are the mandatory administrative application paths to be exhausted before filing a lawsuit. Complaint applications shall be submitted to the contracting authority, Appeal applications shall be submitted to the Public Procurement Authority through signed petitions. On the following page, we will cover both application methods in detail. Before this stage, we could look at who may file complaint application to the contracting authority and appeal applications to the Public Procurement Authority. Potential tenderers, candidates and tenderers who claim that they have suffered a loss of right or damage or likely to suffer a loss of right or damage due to unlawful acts or actions within the procurement process may file a complaint or an appeal application in line with the principles of the public procurement law. Potential tenderer means natural or legal persons or joint ventures formed by those persons operating in the field of the subject matter of the contract and have purchased the procurements or pre-qualification documents. Candidate means natural or legal persons or joint ventures formed by those persons applying for pre-qualification. Tenderer means the supplier, service provider or works contractor submitting tender for procurement of goods, services or works. Potential tenderers can apply the submission of pre-qualification or procurement documents, the arrangements included in the pre-qualification or tender notices or in their documents, and incompatibilities between these regulations and administrative practices. Candidates can submit complaints and appeals about the submission and evaluation of pre-qualification documents and pre-qualification decisions in the restricted procedure. Tenderers. These persons can file complaints and appeals about the submission and evaluation of pre-qualification applications or procurements and the finalization of the procurements. Before dealing with how the review and remedy system works, we can talk about the basic rules of the whole system. Without filing a complaint to the contracting authority, it is not possible to file an appeal to the Public Procurement Authority. A lawsuit shall not be filed before the courts without the exhaustion of complaints and appeals. If a lawsuit is filed before these ways are exhausted, the application documents are sent to the contracting authority or Public Procurement Authority by the relevant court, regardless of the case. To file an appeal after the complaint application or to apply for administrative jurisdiction after the appeal is subject to the discretion of the complainant. Withdrawing appeal application shall not constitute an obstacle for the Public Procurement Authority to review the application and take the decision. Since the decisions taken by the Public Procurement Authority upon appeal may be filed to the administrative jurisdictions, the decisions of the authority shall not be brought to the authority for re-examination. The review periods of the complaint and appeal applications start from the date the complaint or appeal petitions prepared by the complainants are entered into the records of the contracting authorities or the Public Procurement Authority. In case of any deficiency in the complaint or appeal petitions, it is possible to correct these deficiencies until the end of the application period. A person may not apply against more than one procurement, and more than one person may not apply against the same procurement with the single petition. In the petitions, it should be clearly written which acts or actions of contracting authority are unlawful. The complaint applications shall be submitted to the contracting authority by hand, by mail, or by using e-signature through electronic public procurement platform. And the appeal applications shall be submitted to the Public Procurement Authority by hand or by mail. Reviewing of complaint applications by the contracting authorities. Complaints claiming illegality of acts or actions in procurement process shall be made to the contracting authority within 5 days for public procurements concluded according to the subparagraphs B and C of Article 21, and 10 days for others, from the date when such acts or actions are noticed or should be known and before signing of the contract. For reviewing of complaint applications, the examination can be carried out by the contracting officer in person or by one or more rapporteurs assigned by the contracting officer. The contracting authority shall conduct the necessary review and shall take a reasoned decision within 10 days following the complaint. The decision shall be notified to the complainant and other candidates, tenderers or potential tenderers within 3 days after the date of the decision. Potential tenderers are not notified about the decisions other than those against the tender notices, procurement, or pre-qualification documents. Upon the applications, reasoned decisions to be made by the contracting authorities are cancellation of the procurement in case of detection of violation of law, which would constitute an obstacle for the continuation of the procurement process and which cannot be remedied by taking corrective action. Ordering corrective action in cases where the problem may be remedied through correction and where it is not necessary to interrupt the procurement process. Rejecting the application in cases where the application does not comply with the related rules on time, procedure, and form. The contract has been signed properly, and no infringement of law could be detected. If no decision was taken in the specified period, the complainant may appeal to the Public Procurement Authority within 10 days following the expiry of the decision-making period. And if the decision taken is not deemed appropriate, potential tenderers, candidates or tenderers, including the complainant, may appeal to the authority within 10 days following the notification of the decision of the contracting authority. If a complaint is submitted to the contracting authority, the contract cannot be signed unless 10 days elapse from the final notification date of the decision taken upon complaint or from the expiration of decision-making period where no decision is taken, without ensuring that no appeal is made, or where there is an appeal to the authority unless the Public Procurement Authority makes a final decision. Reviewing of appeal applications by the Public Procurement Authority. We know that the potential tenderers, candidates or tenderers who have submitted a complaint to the contracting authority or who have considered the decisions of the contracting authority inappropriate may file an appeal to the Public Procurement Authority within 10 days. Among the acts and decisions related to cancellation of procurement, only those taken upon complaints and appeals can be a subject matter of an appeal, and this appeal is submitted directly to the Public Procurement Authority within 5 days. The authority shall review the appeals in terms of claims of applicant, matters stated in the decision made by the contracting authority upon complaint, and whether the principle of equal treatment is infringed with respect to acts complained about. Review of appeals to be submitted against the decision of the contracting authority to cancel the procurement upon a complaint or appeal shall be limited to reasons of the cancellation by the contracting authority. While reviewing the appeals, at the first stage, the Public Procurement Authority evaluates the applications according to the preliminary examination issues. These issues, whether the subject of application is in the field of duty of the authority, whether there is a necessary capacity to apply, whether the application has been made on time, whether the relevant documents showing that the applicant, if any, the attorney or representative, is authorized to apply are in the petition, whether the name of the contracting authority and the procurement or tender registration number are specified in the petition, whether the date of the realization of the situation subject to application is specified in the petition, or whether the date of notification is indicated in the petition. Whether the date of application to the contracting authority, and if any, the date on which the contracting authority's response was notified to the applicant is specified in the petition. Whether a copy of the petition of complaint submitted to the contracting authority and a copy of the decision taken by the contracting authority upon complaint are attached to the petition. Whether the application fee has been paid. Whether a person has applied against more than one procurement and more than one person has applied against the same procurement with a single petition. Finally, whether the evidence based on the subject of applicant and its reasons are specified in the petition. As a result of the preliminary examination, if a violation is detected, a preliminary examination report on this issue shall be prepared and the Public Procurement Board shall decide to reject the application. If no contradiction is detected, the application shall be sent for the substantial examination. Upon the applications, reasoned decisions to be made by the Public Procurement Authority are cancellation of the procurement in case of detection of violation of law, which would constitute an obstacle for the continuation of the procurement process and which cannot be remedied by taking corrective action. Ordering corrective action in cases where the problem may be remedied through correction and where it is not necessary to interrupt the procurement process. Rejecting the application in cases where the application does not comply with the related rules on time, procedure, and form, the contract has been signed properly, no infringement of law could be detected, or the matter which subject of the appeal is not within the authority's field of duty. The authority is obliged to make the final decision on the appeal within 20 days, following the date on which the required documents, information, and procurement process dossier of the procurement under review are received by the authority. The period shall apply as 10 working days for appeals against procurements concluded pursuant to subparagraphs B and C of Article 21 and against decisions to cancel the procurement upon a complaint or appeal. The authority, when deemed necessary, may ask opinions of experts on the technical issues, which requires certain expertise. And the Public Procurement Board, when deemed necessary, may decide to hear the parties and the relevant persons. All decisions taken by the board shall be notified to the parties within 5 working days, following the date of the decision, and they are published on the website of the authority within 5 days following that notification. No fee may be collected for access to the decisions. Contracting authority shall immediately take action required by the board decisions, which change the legal status. Those concerned who claim that the decisions of the board, which changed the legal status, were implemented incompletely or incorrectly, may take the application regarding this issue directly to the authority as appeal applications. If the decisions taken by the board are not implemented at all, a criminal complaint can be made directly to the office of the Chief Public Prosecutor. The final decisions made by the Public Procurement Authority with regard to appeals can be challenged before Turkish courts, and such cases shall have priority. Within this framework, a lawsuit can be filed against the decisions of the authority at the Ankara Administrative Court, which is the first instance court. The appeal authority of both parties against the decision taken by the Ankara Administrative Court is the Council of State. It has been decided that the lawsuits regarding public procurements shall be executed by the summary procedure. According to the summary procedure, the period of filing a lawsuit against the decisions of the authority is limited to 30 days. Finally, we can look at numbers of the appeals and decisions regarding the review and then complete our presentation. The number of procurements that could be complained in 2019 was 64,871. 2.87% of the procurements that could be complained were filed with appeal applications. Among these appeal applications, the most complained type of the procurement was the procurement for works, and its share in the total was 5%. When we look at the numerical and proportional distribution of the decisions taken by the Public Procurement Authority, in 2019, a total of 1,767 decisions for appeals were taken by the authority. According to the types of the decisions, the rate of the rejection of the application was approximately 67.3%. The share of ordering corrective action was 25.8%. The share of annulment of procurement proceedings was 4.9%. And finally, the share of annulment of termination of procurement proceedings was nearly 2%. Every year, on average, 85% of the decisions taken by the authority are not challenged before the courts. It means that approximately 85% of the complaints in our country are resolved by the decisions of the Public Procurement Authority. We finish our presentation here. Thank you for joining us.